Good afternoon and welcome to Law and Crime. I'm Angelica Spanos. Thanks for joining us today. We have a new trial we'll be covering live on Law and Crime. All right, so those were the prosecution's opening statements. Joining us today to talk about all of this and break it down, we have Byron Browne, trial attorney. Byron, thanks for joining us today.
Thanks for having me on, Angelica.
So first off, did you think that the prosecution's opening statements were effective here?
I think they were. I mean, their whole job in an opening statement is to lay out what the evidence is going to show throughout the trial. And she did that piecemeal, and that's exactly what you want to do to the jury. You want the jury to be able to follow along with the opening statement and then remember what that opening statement is, because an opening statement is only as good as the evidence that's going to be produced at the time of trial. So I think they did a really good job.
All right, I completely agree. And the defense went on with their opening statements, which, as you'll hear, I don't think were as compelling here or as interesting. So let's listen to those. So that was the defense's opening statement, and that was completely different, a lot different than what we heard from the prosecution there. Byron, when you watch that and compare it to what we saw from the prosecution, completely different in the sense that we heard him going through a lot of legalese, a lot of the protocol and things like that. He didn't mention his client at all. He didn't talk about the crime. What do you think here?
I think that means that he knows he has a dog of a case. When you keep emphasizing the other side's burden, which is essentially what he did, is he just kept throwing it against the prosecution, saying, hey, ladies and gentlemen of the jury, the prosecution has to prove this beyond a reasonable doubt. So he wants to kind of deflect all the attention off of his client and make sure that the prosecution proves their case. With him not articulating one point or one strength in his client's case up until this point, tells me he knows he has a weak case.
And he didn't even mention his client or the crime at all, which I also thought was interesting. What do you make of that? Is this an effective method?
I don't think it's an effective method at all. And if I was the prosecution in closing arguments, I would use that opening statement against them by saying, look, he hasn't produced anything. And the whole point of an opening statement is to tell the jury what the evidence is going to show. The fact that he hasn't mentioned his client or any evidence tells me he has no evidence to prove his client's innocence.
Let's get into talking about the medical examiner now. Shondell Summer, attorney, and Byron Browne, trial attorney, with me today to talk about this. The ME was one of the most compelling witnesses we had here. This really gave a lot of insight into the extent of those injuries. He talks about the suffocation and all of that. Shondell, I'll come to you first. What did you think of this testimony, and how does this play in to this trial?
Well, obviously, it made a big difference in terms of the idea that she died a very painful and horrible death. The medical examiner was very well-spoken. He had very short, brief answers to the questions. It wasn't complicated in the least. And the prosecution did a very good job of making what can be very complicated testimony understandable and compassionate.
Absolutely. And Byron, is there anything you wanted to add to that?
No, I think that's exactly what happened. Is that witness testified very well, and the prosecution, just like Shondell said, did a very good job of having the medical examiner break things down, just like asphyxiation. Sometimes we all think that that's a common understanding, so it's really good that the witness took the time to explain the details.
All right, Byron, thank you. After the prosecution put on the evidence, the verdict came out. We're going to play that for you if you haven't seen it yet. So there you have the verdict there. Guilty across the board for Nelson. This did not come as a big surprise when we watched this play out here on the network. Byron, I'll come to you first. What are your thoughts on the verdict and really the case in general?
Well, I think the prosecution did a really good job. They did what they said they were going to do in their opening statement. They produced the evidence that proved his guilt, and that came through as they polled the jury. Every juror came to the same conclusion, so I think it was clear that the prosecution did a great job.
And Shondell, what about you?
I think guilt was a foregone conclusion, especially when you have the defendant testifying and confessing during the trial that he committed the crime. If the jury didn't find him guilty, they need to probably conduct some type of mental examination on the jurors. it doesn't get any more clear than that. And these types of situations where a defendant comes in and confesses to such a brutal murder are few and far between.
Right, and we also had an instance here where he also took the stand. We're going to get to that in after the break. But if this was you and you have someone like Nelson here who wants to take the stand, and he did this against the advisory of his team, how do you react to that? What do you say to someone like that, Shondell?
Well, you probably scream a lot at this point. And you're telling them you're making a huge mistake. This guy has a death wish, I'm convinced. He wanted the death penalty because he doesn't like being in prison. He made motions about the quality of the food and the fact that he had lost 40 pounds and thought he was being treated poorly in prison. So he was doing everything he could to get convicted. When you have a client like that, I don't know what the answer is. I don't know what you do. I've had situations like that, and you just keep fighting, and you just try to remember it's your constitutional duty to defend someone despite the circumstances.
Right. All right. And Byron, weigh in on that, too, because this was a very interesting part of this trial. And one of the reasons why it garnered so much attention was because we saw the defendant on the stand. But not only that, some of the content of what he said. And as I said, we'll get to that after the break. But what do you think if you were put in this situation? What would you have done?
Yeah, the only thing you can do is provide the best counsel. Obviously, his lawyer told him not to take the stand. He went against the advice of counsel. So at that point, as the lawyer, all you got to do is keep fighting and arguing the best that you can. This guy's a self-described homicidal maniac. So there's very little you can do once your client is headstrong on going against your advice.
Right. All right, and before we take this break, as I said before, after the break, we're going to play the defense. The defense called only one witness to the stand, which was Nelson, and this was all during the guilty phase. And that's the first time that we saw him on the stand, and that's when things got a little interesting. So going off that nugget real quick, what do you all think about him taking the stand in general? I mean, obviously, as we just said, you can advise against it, but what's your reaction to him doing that and knowing now in hindsight what was said? Shondell.
Actually, he has an absolute right to take the witness stand. In criminal trials, at the conclusion of the evidence, the judge will ask the defendant, do you want to take the witness stand in your own defense? And the defendant has to state unequivocally that he does not wish to take the stand. So you absolutely have a right to take the witness stand and testify. And most defense attorneys are going to advise against it, because if there's any doubt whatsoever of the person's guilt, a lot of times they can provide that evidence by taking the stand and sort of deep-sixing their own case. So it's not conventional wisdom would be that you don't have your client take the stand under any circumstances. But in this case, like I said, I think the guy really wanted to be convicted, wanted to get the death penalty, in fact, and didn't want to stay in prison for the rest of his life. So I think this was a situation where the jury just sort of threw the guy in the briar patch.
Right. Very rare instance here. All right. Well, as I said, we're going to play you when our defendant takes the stand coming up. We're taking a break right now. Stay with us, though, because we'll show you that after this.